The aim of this talk is to talk about witness statements. Hopefully it's not a talk to teach you to suck eggs. It's a talk where we're going to just go through the working paper that came about in December last year and has led to some changes in the CPR and also some reminders as to what judges are looking for from witness statements. I'll touch very, very briefly on witness statements in applications as well, because they are a bit of a fine art, and also give you some feedback and some helpful hints and tips that I've been given from judges, and the judges in Birmingham actually gave to a variety of practitioners as a talk they did in March. So I hope you've all got a cup of coffee and you're ready to get going. Like I say, any questions as they pop up, do please ask. So as I mentioned, there was a witness evidence working group and they published a final paper in December 2019. And that working group came about from the commercial courts users group discussing as early as March 2018 some real concerns that they had with witness statements. And that real concern sort of sprung up as that the witness statements were not providing the best evidence possible. The working group was made up of judges, barristers, solicitors, and also lay members who frequently use the courts. I think there were actually 2 or 3 members from Barclays Bank on the panel, and they were just discussing the various ways that they thought witness evidence could be improved. They didn't just focus on the negative. They did obviously find that there were some advantages in the way that we do things in the commercial courts at the moment. But the view that they formed, the overriding majority and the overriding majority of judges in the commercial courts felt that witness statements were ineffective. And there were reasons for this. They felt that witness statements had become too lawyered. There'd been too many variations of the witness statement, various drafts that had gone back to the witness that tarnished or corrupted the memory of those particular witnesses. I'm sure we're all familiar with, if you tell a story, the story might change every time you tell it slightly. And that's not because of anything other than just memories and influences in comments perhaps that people have made to you. It's not that you're deliberately changing your story, it's just it comes out in a different way. And there was a real desire to try and prevent that from happening going forward. So there was a suggestion that in fact actually witness statements should be done away with in the commercial courts, the civil courts and the business and property courts, and witnesses should actually give evidence in chief as they would do in the criminal courts. That obviously sent a cold chill down a lot of civil practitioners' spines, as, to be honest, that's just not something that we do, and not many of us have practice in that area of giving leading your witness through evidence in chief in the civil courts. So what the approach was actually, let's see what ways we can improve witness statements. And this actually did lead to some changes in the CPR, which we'll come on to very shortly. As I said, they didn't just focus on the negatives. They did see that there were some advantages in the way that witness statements are used at the moment. For example, parties lay their cards on the table. You can see what the evidence is going to be at trial, and you might be able to negotiate with your opponents using those witness statements in the lead up to trial and settle the matter. Some of us might say that maybe that comes slightly too late and a lot of costs have been incurred at that point. But that was something, again, that the working group noticed, was that because witness statements are becoming so manicured, so much time and costs were being incurred in putting those witness statements forward. So there were just ways in which they identified that perhaps we could improve witness statements and their reach. So what have been the changes that have come forward? Some of these recommendations in practice direction have always been there, and for one, in fact, they're not new recommendations, but it just hammers home the points. So in the practice direction 32, witness statements are to be in the witness's own words. What does that mean? Well, quite often I will get a witness statement from a solicitor, and the solicitor will say, please make any amendments you deem necessary. The biggest temptation of anybody taking a witness statement or reading a witness statement is that perhaps you want to use a word that's different to what the witness has used. And the reason for that is you feel it has slightly more punch. But we must resist that temptation to alter the words. Use the words that the witness has given you during you proofing them and taking that witness statement. Judges, and especially those judges in Birmingham when we went to the panel discussion, said very clearly that one of the most unattractive things about witnesses is when in their witness statement they've used words that you can quite clearly see when they're actually giving their evidence orally they would never have used, and it makes them discount or add less weight to that particular witness's evidence because they're thinking, well, the evidence in chief I've got from you obviously isn't how you would express yourself. And the second point there, to be in the witness's own language. Now, I wrote an article on this and the amendments to the practice direction earlier this month. And one of the questions that arose from that was, well, what if the witness can speak English proficiently, it's their second language, they operate it in a business capacity, they understand, do I still need to write it in their native language? The answer to that is, in my view, no. If your witness can speak English proficiently, understands, converses with you, instructs you in English, then write the witness statement in English. In terms of if you do have a witness statement that is in the witness's own language, obviously there are additional rules there that then bite in terms of translating that witness statement. So the witness statement must be translated into English. The translator must sign the original statement and also the translated statement and confirm this is an accurate record. And then when filing with the court, you as a solicitor must file the original witness statement in the witness's own language together with the translated copy. An additional point there is the statement of truth must be in the witness's own language on the original statement as well, so the witness can fully understand what it is that they're signing. A new requirement in the practice direction is that the witness statement must set out how it's been compiled, and this is one of those matters that did come out of the working group. So in the body of the witness statement now, it's helpful to see how it is that witness has given your evidence. In fact, you must set that out. So did the witness write their own witness statement? Did the witness give you the evidence over a series of telephone calls? Did you meet face to face with them? Did they send you a series of emails? How is it that you proof that witness? And that must now be contained in the witness statement. It seems to me that that's to add some accountability really to the solicitors. If a witness was to sit down and say, giving their examination, in cross-examination to say, well, that's not how I expressed myself. It's now pointing the finger slightly and giving more accountability to the solicitor in the way that the witness statement has been drafted. So it's an attempt to combat some of these issues that the working group had identified in the witness statements becoming too lawyered. As we all know, witness statements are to be verified by a statement of truth, and that has been amended slightly. which I've got a separate slide on in a few moments, and we'll be able to look at the additional wording that's been added. And also the witness statement is to set out which of the matters within the witness statement are within the witness's own knowledge and those that are not. I've just noticed a typo on my slide, so that's not good. That really is to combat this idea of hearsay evidence. Now, I've put in there a case, Starbucks and British Sky Broadcasting. And in this case, the judge did go to town on the lawyers because a witness in that case simply just didn't come up to proof whilst she was being cross-examined. There were matters within her witness statement that she had no direct knowledge of, and she had to concede those matters during cross-examination, but it hadn't been set out in her witness statement that those matters were not within her own knowledge. Or even she didn't set out the source of that information. And the judge was very scathing of the lawyers there and said, well, you've completely failed that witness because you know the rules, it's a breach of the practice direction, and you haven't set out where in fact this witness has got that from. And it amounts to hearsay. So what weight am I now going to add to that? Especially as, to a certain extent, you have misled the court in making the court think that this was the witness's own evidence that she had direct knowledge of, when in fact it's not. Just commenting very briefly on hearsay, I'm sure as much as possible, many of you avoid hearsay in witness statements. If there is a point that is absolutely crucial to your witness statement, to your case rather, then one would imagine you would have a witness who is able to talk about that, and other witnesses don't need to comment on it. So for example, if there is a crucial email between Director A and Director B, and Director B is the defendant, hopefully you've got Director A who's able to provide a witness statement rather than Director C who's just commenting. That will fully strengthen your case rather than relying upon hearsay. As we all know, it's within the court's discretion as to how much weight they apply to that. So the practice direction obviously is the place we'll all start when we're wanting to check rules, and the CPR rules also. But also it's worth noting that the court guides do provide some guidance as to how your witness statement should be drafted. And it would be useful when you begin to draft a witness statement, or just before you begin, to just go and check the relevant commercial guide. What I haven't got on here is the Chancery Court Guide, because frankly it agrees very much with the Commercial Court Guide and the TCC Guide. But there are just some key points that are worth drawing out of both of those guides. So the Commercial Court Guide expressly states that the witness statement is to be as concise as the circumstances allow. There's actually a page limit on witness statements in the Commercial Court Guide of 30 pages. What is supposed to happen if you're going to go over 30 pages is that you're supposed to make an application to the court and seek permission to go over that page limit. I'm not sure how many people do that. If you don't, then of course you can submit that witness statement, but it's a very tense moment as to whether the court is going to allow that in, or whether they'll strike some of it through. So really you should be making those applications. But ideally, witness statements should be not more than 30 pages. I mean, 30 pages, you're going to have quite a large dispute there to warrant anything over 30 pages. It's also worth considering, is there anything that you can do with the other side early on? So for example, can you agree some agreed facts? Those that are not contentious, can you have a separate document that you agree early on with the other side, so your witnesses don't need to spend time in their witness statement going through things? And frankly, the judges in the working group said lots of witness statements spend a lot of time going through facts and matters that are actually agreed between the parties and add nothing. What they're interested in are the disputed facts and evidence, and that's what they want the witness statements to focus on. The Commercial Court Guide also suggests that witness statements address things in a chronological order. Now, you may have particular issues in your case. So, for example, you want to deal with issues A, B, and C, but they occur at different or matters relating to those span across the chronology. So you might find that you're going backwards and forwards, or your issues are not very clear. What it might be useful to do, again, is to just set out your chronology, just have a background section of the witness statement, and then address those issues by reference back up to that background. Or you might choose that you will do your witness statement issue-based and just identify the chronological points in issue A, and then refer back to the facts that you need to in those later issue sections. And again, this point that the witness statement should be confined to the facts that the witness can give evidence upon. So this is not commenting on matters and documents that are not within their knowledge, and just for the sake of trying to persuade a judge that a document says a particular thing. It's just not going to wash. And one key point that I took away from the TCC guide is it expressly states that a witness statement should not be argumentative. So it should, going back to this idea of tone and just completely neutral. And yes, you want a judge to believe your witness, but it's not a witness's job to be persuasive. It's a witness's job to provide the evidence, the facts and the matters in the manner that they actually occurred. The need to be persuasive is a job for the advocate and the skeleton argument, their cross-examination, their submissions. There's no need for a witness to be argumentative or necessarily hostile in the witness statement. So it's interesting, there's a case earlier this year in March, PCP Capital Partners LLP and Barclays Bank, which shows the extent to which judges now will comment on witness statements. Mr. Justice Waitman was actually a member of the working group, and he took it upon himself a pre-trial review to comment on witness statements that had been provided. He was particularly unhappy with the fact that a witness was commenting on matters outside of her knowledge, and in fact was commenting quite in quite some length about the contents of documents and providing narrative of those documents in the witness statement. That's a point I should have mentioned, is that witness statements shouldn't recite lengthy passages of key documents or even documents in the witness statement. Just refer back to them. There's no need to just put massive passages in there for the sake of it. But back to PCP, the judge actually found at that point, at the pre-trial review, that it was inappropriate for much of the witness statement, in fact, witness statements to go through to trial. We don't know what documents and what passages the judge took issue with, because they were contained in a confidential annex to the judgment. But he did say that, you know, these are the matters that the witness should be commenting on: what they know, what they thought, what they believed, or what they intended, and what they believe, you know, and they can do that about facts or meetings or even documents, but don't stray outside of those. You should just not be going there. So I think that we will see a tendency now for judges to be more direct about witness statements and more prepared to strike matters out of that witness statement and not allow them to progress forward. Historically, it's been for parties to address whether they believe there are particular issues with a witness statement and therefore there's inadmissible evidence that should be struck through. But I think this does show a more direct approach from judges. As I said earlier, we have had an amendment to the Statement of Truth It's now contained at Practice Direction 32, paragraph 20.2. And so the additional wording is, I understand that proceedings for contempt of court may be brought against anyone. Now, the reason for this is it was believed that the simple statement, I believe that the facts stated in this witness statement are true, was just too brief, and witnesses weren't fully understanding the implications of what they were signing. They didn't understand if they were found to be untruthful and what the consequences of that. So really this additional sentence has been to hammer home the consequences of doing so. It's important to state that actually this new statement of truth goes across all documents that are to be signed by a statement of truth. So your particulars of claim, your defence, RFIs, or whatever it is. So those of you who in the past have signed a statement of truth on a particulars of claim for your client, you might want to reconsider doing that, considering this new additional wording. I'm sure you all thought about it very carefully before doing it anyway, if you did, but even more reason, I think, to have your client sign the documents. So we focus quite a lot really on witness statements for trial and your lay witnesses, but what about if you are making an application? The key wording in CPR Practice Direction 23 is that the court needs to be satisfied with the evidence of facts that are relied upon. Now, I appreciate some of you might be sitting there and scratching your head and saying, well, for a summary judgment, we have to address certain criteria. For an injunction, we might have to address certain criteria. Now, that's fine, and I'm not saying that you can't address it in that way. For example, you might set out, is the defence more than merely fanciful? That might be one of your headings, but underneath that, what you might do is set out the actual facts that you rely upon. What judges, and particularly those judges in Birmingham, commented on is where they see witness statements that are so clearly skeleton arguments or so clearly legal arguments that it really puts them off. So, for example, you might have the phrase in there, I submit that for these reasons the application should succeed, or quite often what I've seen, a closing paragraph that says it's respectfully submitted that. You can provide that witness statement in applications without those phrases. So, for example, you can just slightly change language and say, for the reasons above, or the application seeks, rather than saying it should succeed, it's saying, well, they're the reasons why we seek it. So it's just thinking about how you present it. There's nothing wrong with presenting things. It's just making sure you present it as evidence of the facts and not so clearly a skeleton argument, because you're instructing advocates to do your applications, then you're expecting them to do a skeleton argument. And if you've almost presented a skeleton argument to begin with, you're confining the boundaries of where the advocate can go. Yes, they're confined by the witness statements anyway, but you may have presented the arguments for them and they're thinking, well, I might have presented it in a slightly different way to that, but they're pretty much bound and stuck by the way you've presented it. So it's just thinking about the phraseology, the terms used, and just making sure it does come across as a witness statement of fact. Also, just to remember, if you're going with a without notice application, you've got additional duties on you there to make sure you give full and frank disclosure. So your witness statement is going to be much more far-reaching and cover a lot more issues than it would if you were going on notice. Now, the last slide that I have isn't strictly related to witness statements, but more to the idea of giving remote witness evidence. And I thought it useful to touch upon this, just given the times that we're in and the fact that the courts are now preparing to hear more trials by by video link or Skype or whatever. Amazingly, I've just had a case confirmed that's going to be heard in Worcester over a number of days by Skype. So it does show that there's an appetite now for the courts to be going ahead and not adjourning and postponing things. So just some practical tips for you to consider if you've got a case coming up in the near future. Well, first and foremost, the practical tips for your witness. Make sure their internet connection works, make sure they have access to the documents that they're going to need electronically, make sure they can be somewhere where they're free from distraction. I appreciate much more of us are doing childcare or working in environments we're not used to, so you might have your cat or your dog walk across. If possible, ensure that the witness can be free from distractions, particular things, turning emails off, mobile phones, landlines, doorbells, those types of things. But it's worth asking them early on, are they going to take an oath or an affirmation? If they're going to take the oath, make sure they have the appropriate holy book. You may have some witnesses that are international. It doesn't look like they'll be able to fly into the country anytime soon. Sorry for anyone who was hoping they may be going on holiday, like myself. So take into account time differences, scheduling those witnesses to account for time differences, and making sure that the witness fully understands in their local time, as well as a GMT time, what time they'll be giving their evidence. I had a particularly embarrassing experience a few years ago where I'd arranged for a witness in America to give evidence via video link. We'd made sure he knew the time several times. We thought we were on the same page. But what I didn't know was that actually the week before he gave evidence, the clocks changed in America. So he thought I was talking about the pre. Sorry, he was talking about the pre-clock time, and I was talking about the after-clock change time. So we had an embarrassing moment where frantically I was in the Rolls building trying to arrange for him to get to the venue to give his evidence. So just make sure you fully understand each other there. Also, are there any diplomatic issues? So some countries do actually have issues with their nationals giving evidence on their soil in an English court. There is a really helpful link on the Foreign and Commonwealth Office website in their legal office, which sets out the countries that effectively don't have an issue. It's worth just checking that just to make sure, and also be prepared as lawyers to answer questions if the judge asks you, have you checked that there are no diplomatic issues? I don't know how many of you that might affect, but it's useful just to know. And then obviously, in terms of remote witness evidence, some lawyers, some advocates love it, some loathe it. It's a very different experience cross-examining someone on Skype. So, it's a useful experience for everyone to see. And hopefully the courts will do their very best in the near future to hear as many trials as possible. So the main takeaways really, when you are doing your witness statements and you're drafting them, just think about those why, what, where, how, who questions. Make sure it's as much as in the witness's own words as possible, and don't over lawyer it. Don't try and close the holes. A witness statement that is authentic and is true to the witness is usually much more well received than something that's over lawyered, closing the gaps, and just looking for very little wiggle room. That draws to a close what I have to say on witness statements. If anybody has any questions, then please do let me know. You can email me at kwhite@st-phillips.com, and I will answer your questions as best I can. I have had one question pop up as to the website for the Foreign and Commonwealth Office and how to check if there are diplomatic issues. If you just go into the Foreign and Commonwealth website, there is an option for the legal office there, and you can check on the legal office drop down menu remote evidence in foreign countries, I think the link is called, and it is on there on the Foreign and Commonwealth Office website. As I say, if you have any questions, please do send me an email or email Aaron and Justin. But thank you very much for listening this morning. I hope it's been useful, and enjoy the rest of your day. Thank you.